If I am Carter Page or his attorneys, I am reading Kevin Clinesmith's sentencing memorandum very, very closely. Viva Frei, Montreal litigator turned YouTuber, and earlier this week I did a vlog breaking down Carter Page's civil lawsuit against the Department of Justice, the FBI, James Comey, Andy McCabe, and a bunch of other people at the FBI for damages he sustained as a result of their wrongful conduct. If you haven't seen that vlog yet, give it a watch. It is on both YouTube and Rumble, but in a nutshell, Carter Page alleges that the Department of Justice, the FBI, Andy McCabe, James Comey, Peter Strzok, and a bunch of other individuals at the FBI engaged in unlawful surveillance on Carter Page. The lawsuit alleges that the FBI obtained who's this? My wife. Better answer it.
Hello?
The lawsuit alleges that the FBI wrongly obtained 4 FISA warrants, that members of the FBI, Strzok and Page in particular, wrongly leaked information obtained through those FISA warrants to the press to damage Carter Page's reputation. The lawsuit highlights, as I pointed out in that video, that
you can't trust the system!
Also alleged in that lawsuit is that a lawyer for the FBI, one Kevin Clinesmith, wrongly altered, modified, deleted a line from an email that he had received that confirmed that Carter Page was in fact a source for the CIA before submitting that documentation to the SSA, which is the supervising secret agent, in order to obtain the 4th FISA warrant. Now, that is undoubtedly a mouthful that might not make total sense to anyone who is not totally familiar with the situation, but as we go through this document, it will become abundantly clear what exactly is going on and how bad the behavior actually was. Kevin Clinesmith subsequently pleaded guilty to making one false statement to the FBI, but in reality, his behavior was so much more egregious than the headlines that the mainstream media ran with. Clinesmith pleaded guilty, and the Department of Justice just submitted a sentencing memorandum where they are asking for actual prison time, but what is alleged in the sentencing memorandum will blow your mind. Now, fair warning, I might by accident refer to Clinesmith as Kleinfeld, who was the lawyer from Carlito's Way. If you've never seen that movie, watch that movie. It's an absolute classic, and I also reserve the right to use a lot of Kevin memes from Home Alone. Kevin! With that said, let's get into the sentencing memorandum so we can get all of the nitty-gritty details. United States District Court, District of Columbia, United States of America versus Kevin Clinesmith, defendant. Government's sentencing memorandum. The United States of America, the government, respectfully submits this memorandum in aid of sentencing of defendant Kevin Clinesmith. On August 19, 2020, Clinesmith pleaded guilty to 1 count of making false statements in violation of 18 U.S.C. Section 1001A3. The government respectfully submits that a sentence of incarceration that is at least between the middle and upper end of the applicable sentencing guidelines range is appropriate and warranted. The government is asking for actual prison time for Clinesmith for having pleaded guilty to making a false statement to the FBI, and I know a lot of people are going to reflexively compare this to another very famous example, say Roger Stone, who was found guilty of having made false statements to the FBI. Wait until you see the details of what Clinesmith actually did. The mainstream media painting it as only having made a false statement to the FBI really doesn't do justice to the situation, pun intended. On July 31, 2016, the Federal Bureau of Investigation, FBI, opened an investigation known as, quote, Crossfire Hurricane, into whether individuals associated with the Donald J. Trump for President campaign were coordinating activities with the Russian government. By August 16, 2016, the FBI had opened investigations under the Crossfire Hurricane umbrella on 4 individuals, including an individual identified in this case as, quote, individual number 1, end quote. And although they never actually identify individual number 1 in this sentencing memorandum, I strongly suspect that they are referring to Carter Page. The defendant, an FBI attorney in the Office of General Counsel, was the principal line attorney assigned to provide legal support to the Crossfire Hurricane team. Among other things, he worked on applications to the United States Foreign Intelligence Surveillance Court to conduct surveillance on individual number 1 pursuant to the Foreign Intelligence Surveillance Act. There were a total of 4 court-approved FISA applications targeting individual number 1, which allowed the FBI to conduct surveillance on individual number 1 for nearly a year, from October 2016 to September 2017. On August 17, 2016, prior to the approval of the first FISA application, another U.S. government agency, OGA, provided the Crossfire Hurricane team with a memorandum, August 17 memorandum, indicating that individual number 1 had been approved as an, quote, operational contact, end quote, for the OGA from 2008 to 2013, overlapping in time with his interactions with known Russian intelligence officers described in the FISA applications, and detailing information that individual number 1 had provided to the OGA concerning individual number 1's prior contacts with certain Russian intelligence officers, at least one of whom was discussed in the FISA applications. The translation of what is being described here, the OGA, the other government agency, from what I understand, was the CIA confirming that individual number 1, Carter Page, was in fact a source for the CIA from 2008 to 2013. My understanding is that this was an extremely material fact in that it would explain away certain facts as to why individual number one, who I think is Carter Page, had certain contacts in the first place, why he was known to the CIA, and that he was in fact sort of a credible person to begin with. As will be alleged in greater detail in this sentencing memorandum, had they disclosed to the FISA courts that individual number one, Carter Page, was in fact a CIA source, they would never have gotten the FISA warrants in the first place. And the fact that they did not disclose this to the FISA courts on the first 3 applications would be used against them, which explains why Kevin Kleinsmith did what he did. In early June 2017, prior to the submission of the final application, and after individual number one stated publicly that she had assisted the US government in the past, the FBI Supervisory Special Agent, SSA, who was going to be the affiant on the final application, asked the defendant to inquire with the OGA as to whether individual number one had ever been a, quote, source for the OGA. On Thursday, June 15, 2017, the defendant sent an email to a liaison at the OGA liaison, seeking clarification as to whether individual number one was an OGA source and stating, quote, there is an indication that individual number one may be a, quote, DIAgraph source. This is a fact we would need to disclose in our next FISA renewal. To that end, can we get 2 items from you? 1. Source check, is individual number one a source in any capacity? 2. If he is, what is a DIAgraph source or whatever type of source he is? End quote. 2 clear questions to the OGA liaison, which also highlight the fact that they ought to have mentioned this in the first 3 FISA applications, and the OGA liaison provides a very clear answer. The OGA liaison responded by email later that same day. Specifically, the OGA liaison provided the defendant with a list of documents, including the August 17 memorandum that the OGA had previously provided the FBI. The OGA liaison also wrote that the OGA uses the DIAgraph to show that the encrypted individual is a US person. We encrypt the US person when they provide reporting to us. My recollection is that individual number one was or is DIAgraph, but the documents will explain the details. If you need a formal definition for the FISA, please let me know and we'll work up some language and get it cleared for use. Later on in the sentencing memorandum, it goes on to allege a conversation that the defendant had with the SSA as relates to the status of individual number one, Carter Page. SSA, do we have any update on the OGA CHS request? Also, case agent said OI attorney is not so optimistic. Defendant, CHS, you're referring to individual number one? SSA, yes. SSA, so individual number one was a DIAgraph or individual number one was a subsource of the DIAgraph? Defendant, it's sick. Sounds like a subsource of the DIAgraph. Defendant, and yes, the OGA confirmed explicitly he was never a source. SSA, interesting. Defendant, but like interesting good, right? Defendant, I mean, at least we don't have to have a terrible footnote. And for anyone who might not truly appreciate what is going on right here, here you have the FBI attorney saying, okay, good, so we can avoid a terrible footnote. That terrible footnote would have had to have been a footnote in the renewal for the FISA warrant indicating that they had not disclosed this material information to the court in the first 3 FISA applications. This is the FBI attorney admitting in his text with the SSA that it would be terrible if they had to disclose now to the court that individual number one, Carter Page, was in fact a CIA source. Yet this is exactly what the OGA liaison just confirmed to the defendant, and what does the defendant do? As reflected in the above conversation, the defendant told the SSA that individual number one, quote, was never a source, end quote, and that, quote, the OGA confirmed explicitly he was never a source, end quote. When the SSA asked if the defendant had that in writing, the defendant responded he did and that he would forward the email that the OGA had provided. Immediately following the above conversation, the defendant forwarded to the SSA the OGA liaison's June 15, 2017 email, which he had altered. The altered email read as follows. My recollection is that individual number one was or is DIAgraph and not a, quote, source, end quote. But the documents will explain the details. If you need a formal definition for the FISA, please let me know and we'll work up some language and get it cleared for use. The defendant had altered the email by adding the words, quote, and not a source, end quote, thus making it appear that the OGA liaison had written that individual one was, quote, not a source for the OGA. In doing so, the defendant made and used a false writing or document because he knew the original email did not contain the words, quote, not a source, end quote. Now, anyone who wasn't fully aware of these details can truly appreciate that this is far more serious than the headline of an ex-FBI attorney admitting to having made a false statement during the Russia probe, as reported by Washington Post. This is a situation where the FBI attorney, in going in for a third FISA renewal to get a fourth FISA warrant, knowing that there was information they ought to have revealed to the court that would have compromised their ability to get that warrant, modified an email to which he was not a party before submitting it for the third renewal. Modifying the body and content of that email to add something that was never included in it in the first place so as to conveniently allow them to not have to make a terrible footnote. After receiving the altered email, the SSA asked the defendant if the SSA could send the email to other members of the team. The defendant responded he, quote, already did on Friday when the OI attorney said we're good to go. Sorry for not CCing you, end quote. Relying on the altered email and after receiving the guidance that they were, quote, good to go on this issue, the SSA signed and submitted the final FISA application to the FISC on June 29, 2017. And then the sentencing memorandum goes on to allege the fact that allows all of the headlines in the media to simply be that the attorney made a false statement to the FBI. The OIG subsequently conducted a review of the 4 FISA applications targeting individual number 1. The OIG discovered the defendant's conduct in altering the email. When confronted with the altered email by the OIG, the defendant initially stated that he was not certain how the alteration occurred, but then subsequently acknowledged that he made the change. After being informed of the OIG's finding, the Department of Justice provided the FISC with notice of the defendant's conduct and the failure to disclose individual number 1's prior relationship with the OGA. The Department of Justice also provided the FISC with notice of numerous other misstatements and omissions that the OIG discovered in its review of the 4 FISA applications. The Department of Justice later acknowledged that with respect to the final 2 FISA applications, there was, quote, insufficient predication to establish probable cause to believe that individual number 1 was acting as an agent of a foreign power, end quote. I don't think I'm exaggerating when I say that these are absolutely stunning judicial admissions that Carter Page is undoubtedly going to use in his civil lawsuit, and I suspect this sentencing memorandum is going to become an exhibit to that lawsuit. There is no dispute that the defendant's total offense level under the sentencing guidelines is 6, and his criminal history category is 1, resulting in a sentencing guidelines range of 0 to 6 months of incarceration. The government respectfully submits that a sentence of incarceration that is at least between the middle and upper end of the applicable sentencing guidelines range is appropriate and warranted. As detailed more fully below, this case is outside the heartland of typical cases under 18 U.S.C. 1001, and as such, a sentence would reflect the seriousness of the offense, promote respect for the law, and provide just punishment for the offense while also affording adequate general deterrence to future criminal conduct. The sentencing memorandum then goes on to describe the seriousness of the offense, but we fully appreciate that by now. We don't need to go over that, but it goes on to make a very important point with respect to the FISA process itself. The defendant's conduct also undermined the integrity of the FISA process and struck at the very core of what the FISC fundamentally relies on in reviewing FISA applications: the government's duty of candor.
Duty.
The FISC serves as a, quote, check on executive branch decisions to conduct surveillance in order to protect the Fourth Amendment rights of U.S. persons, end quote. But it can, quote, serve those purposes effectively only if the applicant agency fully and accurately provides information in its possession that is material to whether probable cause exists, end quote. As a licensed attorney and officer of the court, the defendant took an oath, was bound by professional and ethical obligations, and should have been well aware of this duty of candor. He was an experienced attorney with the FBI's Office of General Counsel and was assigned to some of the FBI's most significant and high-profile investigations. Now, one of the talking point defenses for Kleinsmith in the mainstream media was that he truly believed that Carter Page was not a source for the CIA when he modified that email. The argument put forth by the mainstream media was that Kleinsmith thought he was adding clarity by modifying that email as opposed to misleading the court by modifying that email. And the sentencing memorandum addresses that argument and eviscerates that argument. The government expects that the defendant will claim that although he altered the email and created a false document, he did not intend to mislead anyone and was either confused or truly believed that individual number 1 had not been a source for the OGA. By his own words, however, it appears that the defendant falsified the email in order to conceal individual number 1's former status as a source and to avoid making an embarrassing disclosure to the FISC. Such a disclosure would have likely drawn a strong and hostile response from the FISC for not disclosing it sooner, since the FBI had the information in its possession before the first FISA application was filed. Indeed, in the June 19, 2017 instant message conversation with the SSA, the defendant wrote, quote, "At least we don't have to have a terrible footnote," end quote, explaining that individual 1 was a source. The bottom line in the sentencing memorandum is that Kleinsmith knew what he was doing was wrong when he did it, and he knew why he was doing it. And if it is a question of intentions and political motivation, the sentencing memorandum really leaves leaves no doubt as to the ill intent here. The public record also reflects that political or personal bias may have motivated or contributed to his offense conduct. As noted in the OIG report and PSR, the defendant was previously investigated and ultimately suspended for sending improper political messages to other FBI employees. For example, on the day after the 2016 presidential elections, the defendant wrote, quote, "I am so stressed about what I could have done differently," end quote. When another FBI colleague asked the defendant, quote, "Is it making you rethink your commitment to the Trump administration," end quote, the defendant replied, quote, "Hell no," end quote, and then added, quote, "Viva la résistance," end quote. I am Viva Frei and I do not approve of my name being used in such a manner. The defendant was referred to the Office of Professional Responsibility for investigation for these and other related messages, and in July 2018 he was suspended without pay for 14 days. The defendant's prior disciplinary infraction for expressing his political views in a work setting is a relevant aspect of his background. And as far as I am concerned, I look at Kleinsmith like a pawn in this game, not a king. He is the fall guy. I think there are bigger problems within the FBI as to how this could have happened in the first place. I am fairly certain that everybody in the FBI knew what was going on. They all knew what was going on, and Kleinsmith was just the easiest guy to throw under the bus. Further on, the sentencing memorandum raises arguments that the defendant is likely to raise to argue for no incarceration, and these facts really just highlight the fact that I would not want to be the judge sentencing the defendant. To the extent the defendant asks the court for no jail time based on, among other things, his lack of criminal history, his family circumstances, and the impact this offense has already had on his career, none of these considerations warrant a non-incarceratory sentence. First, the defendant's lack of criminal history is already accounted for in the guidelines range calculation, which contemplates up to 6 months of imprisonment for a first-time offender like the defendant. Second, while the defendant and his wife would like the defendant to avoid jail so he can be at home to help his wife through her pregnancy and help with future childcare after the upcoming birth of their child in March, the defendant's family circumstances are not so unusual as to warrant special consideration. Kleinsmith has a pregnant wife at home who is due in March, and if he goes to jail for 6 months, he is going to be in jail for the last part of her pregnancy and for the delivery of their child. I know the facts, I know the arguments, but I would personally not want to be the judge to put this guy in jail right now. That being said, raising the argument that it is going to ruin my life for the next 6 months while what he did could have ruined someone's life for the rest of their life, it's kind of a difficult argument to make once you got caught with your hand in the cookie jar. In no hyperbolic terms, what Kleinsmith did could have easily, if not did, in fact ruin the life of another human, so it becomes a little bit more difficult to say, now don't put me in jail because you're going to ruin my life after I actively tried to destroy someone else's life. To be sure, the government recognizes the impact incarceration will have on the defendant's wife, who may have to care for their child alone for a period of time depending on the sentence the court imposes. However, this hardship is a result of the defendant's own decision to commit the crime for which he is being sentenced and is no different than any other defendant this court sentences to a term of imprisonment. Finally, to the extent the defendant argues that he has already been punished due to loss of employment and his possible disbarment due to this felony conviction, these circumstances should not mitigate his sentence. Again, these collateral consequences are entirely the result of his own wrongdoing. Moreover, loss of a job and the impact of a conviction on one's career are consequences experienced by most white-collar defendants and do not merit any special treatment or consideration here. Society expects and requires better from attorneys and officers of the court who take the oath to uphold the law and comply with their professional and ethical obligations. These consequences do not negate the need for a sentence of imprisonment to reflect the seriousness of his offense, to promote respect for the law, and to provide adequate general deterrence. The bottom line on this third argument, the fact that he is an attorney, that he might get disbarred, that he's lost his job, should not be an attenuating factor whatsoever. If anything, it should be held against him. He is or was an attorney. He took an oath. He knew better when he did what he did. And by the evidence, he did what he did with malice and political motivation. Conclusion: for the reasons stated above, the government respectfully asks the court to impose a sentence of imprisonment that is at least between the middle and upper end of the applicable guidelines range. Respectfully submitted, John H. Durham, Special Counsel, the Special Counsel's Office. So that is the sentencing memorandum. More interesting than anything else are the facts and the admissions made in that sentencing memorandum that are absolutely going to help Carter Page. And my prediction on the sentence, Kleinsmith is going to get between 1 and 2 months. I do think the court is going to take into consideration the fact that his wife is pregnant and that she should not have to give birth and be raising a newborn without the presence of her husband. I know how a lot of you out there are going to react to that. He is pleading, don't ruin my life while I just spent a couple of years trying to ruin someone else's. I know people are going to argue argue that. I know people are going to feel that, but at the end of the day, justice is human, and a judge is going to take that into consideration in my humble prediction. All right, time will tell, to be continued, and if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Feed me Seymour.
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch. Be sure to check out my weekly live streams with Robert Barnes. We also have a locals page, vivabarneslaw.locals.com. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and above all else, do good in the world and be fair with others. All right, now you know your vlog. Peace out.